Hey, what's up, guys? Welcome to Lost-Planning the Interwebs. I am your host. am Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And don't you dare, you cannot call me late and gay today because we were on time and, well, over budget, but we were on time. I will not stand for this slander of my character. How dare you? How dare you? I guess it's libel since you're typing. I guess. How's it going, guys? Welcome. We have some stuff to discuss, I suppose. We've got the remainder of this Vic Mignogna appeal brief. It's not in the right spot. What am I? There we go. Got the remainder of this appeal brief, which is 22 pages. Although I don't think it's 22 full pages that we have left to go through. That shouldn't be the hugest deal. So we should be able to finish that tonight. No problem. No problem. What is going on? Oh my God. All sorts of stupid, pointless notifications need to go away. Okay. Sorry for the beeping of plugging in a phone. So tonight we're going to go through those and then we'll be done with this appeal brief. Look, I know that the Vic stuff, it's been a year, right? It's been a long time, a lot of coverage, and it is this tedious sort of thing that keeps up. And I know it gets tiring, but this should be the last Vic stream for a little bit, and then we'll be covering some other stuff. We've got Sargon's case to cover. We've got the random drama going on between Kitchener Comic-Con and Anime North. This is some weird happenings going on there that we will probably be talking about this week. And you know, there's always something happening. Sorry, I'm trying to get this Milo's mixed up. There's always sorts of stuff going on, and so you know, we've got some other subjects coming. There's plenty of guests that I still need to contact. I've got a Russell Greer thing that has been a long time coming, and I will be inviting the Sword and Scale guy back on for a show sometime soon. Probably after I get back from Kitchener, I'm going to start figure out a good time with him. And we've got other stuff to cover as well. There's this wonderful world of lawsuits going on all the time. So let's take a look at some more of them. But, you know, I figure we've been pretty committed to covering Vic's stuff. The briefs are major events, and I would like to go through them as they come out so we can keep abreast of what's going on. Because if there's one thing we want to do at all times, it's keep abreast. Right? Right. That said, I have been drinking. I shouldn't pause there because it just sounds like I've been drinking. I haven't. On the show here, I've been drinking swill. We've got Military Special. We've got Fuyu. We've got Jack Daniels. How depressing. So I went out today and I bought this brand new bottle of something I've never tried. But it came in a big flippin' box. And it was kind of pricey. So hopefully it's good. But good Lord. Tomorrow's show is going to have a full whiskey review on this. This is a Middleton Very Rare Irish Whiskey, 2018 vintage release. Okay, yes. Look at this box. There we go. So this is there we go. Look at this thing. So that is tomorrow's whiskey review. So it says production is strictly limited, but it doesn't really say how much it was limited to. So yeah. There's a certificate of authenticity. Oh my god. This is a real bottle of whiskey. So yeah. Middleton Very Rare Irish Whiskey. That'll be tomorrow for the full-on whiskey review. It's apparently, they call it the pinnacle of Irish whiskey. This box is gorgeous. Probably added like $20 to the price. Anyway, I was gonna buy a bottle of Lagavulin 16, and then I noticed that the price on it went up like between $12 and $20, depending on what store I went to. And then I found out there's a whiskey tariff. We went to war over this trash. We went to literal war over the taxing of a beverage, and now we're tariffing. Like, I don't know if it's our tariff that's on there. If it's our tariff, disgusting, and we need to undo it immediately. Why are we taxing whiskey imports? It was crazy. But in I guess protest, I decided to buy this whiskey instead. But I have no idea whose whiskey tariff it is. I don't know if it's something to do with the EU cuckery. I don't know if it's something to do with Brexit. I don't know if it's an American thing. I don't know. But I'm pissed. So what I need for you guys to do is if you could just donate so I could buy I'm just kidding. I was just trying to be a proper e-thought for just a minute and begged for money to buy more whiskey because the price went up, so now I'm poor. No. That is entirely a bit. But yeah, so tonight I will not be drinking the Middleton Very Rare because I don't want to taint tomorrow's review of it. Tomorrow's review, that will be incorporated into the stream topic tomorrow, will be the whiskey review. Today, in just a moment, we're going to pop into this Vic case, and I don't want to spend a ton of time saying I like this whiskey. Because I have a feeling I'm going to like it. The only one Fuyu. Fuyu is bad. It's our tariff against the EU? I knew it. I knew this day would come. Can we please just not tariff? Tariff the coronavirus or something. Every coronavirus import, tax that. Don't tax the good whiskey. I guess I'm drinking American tonight. How depressing. There are good American whiskeys. This just isn't one of them. Anyway. So, that being said, if there are any American distilleries out there who make a good, peaty, smoky American whiskey, please tell me. I will buy you out of stock. All right. Anyway, let's jump in. Gross. Jack Daniels is always disappointing. It's like how do I word this? It's like hearing your cousin is going to jail again, right? Every sip of Jack Daniels is like that. It's like, well, I mean, it's not the worst thing that happens to you. It really probably doesn't have any impact on your day. But it's like, well, I mean, he's going to get jail again, I guess. There you go. That's my review of Jack Daniels. Every sip of Jack Daniels is like hearing that your cousin is going to jail again. So there you go. That's it. That's it. All right. Enough of that nonsense. Let's get into this document. Here we are in the appeal brief one more time. Gimme Skittles now says it's disgusting that Toronto's Anime North has nothing better to do than threaten the staff of Kitchener Comic Con with being blacklisted from all Anime North events for having Vic and yourself as guests. Well, Anime North can show that they are certainly not opposed and not engaging in that activity by having me as a guest at their show. I would love to come. Thank you, Anime North, for inviting me. I'll be there. I'm just kidding. They haven't invited me. But if they did, you know, I would go. We could show them how we do things. And how we do things is drama-free, fun engagement for the fans. Because remember who you're putting a show on for. It's the fans. Fun engagement. Happy times. No violence, no drama, no assaults, nothing weird. By the way, what I just described was Vic's entire last year. No drama, no assaults, no violence, no complaints. Just happy fans who paid money to come to shows. Paid lots of money, bought lots of VIP tickets, paid for lots of things at vendors, paid for lots of art, paid for cool merchandise and imported little Gundam figurines and whatever else. All of those people that Vic brought to shows spent money at the shows, spent money on the shows. That's what happens. That's the legacy. And that's the opportunity that these shows are throwing away. It's literally, shows are tossing out 20 grand by not inviting Vic. Just in VIP tickets, they're tossing out 20 grand. Hey, vendors, shows that refuse to invite Vic, for example, are turning away hundreds of customers that would come to your stand and buy stuff. That's it. If Anime North wants to go ahead and put this to bed, I mean, there's a great way to do it. They should invite Vic, or they should invite me, or both. There's a thought. All right. Philip says, can we host a con and invite Vic? Now, careful. I've already talked too much about hosting a con. I think it would be great, but it takes a lot of work. So we'll see. Maybe not. All right, let's do this document here. We're gonna jump right in. We'll see how this goes. So we're on point of error 5. The trial court's dismissing of appellant's claims against appellees for conspiracy is reversible error. Now this is going to be a little bit of an interesting argument because conspiracy relies on the underlying claims proceeding, right? Conspiracy is not an independent tort. It is a recognition that people engaged in a conspiracy to commit some other tortious act. All right. So the argument about conspiracy, my hip, oh goodness. The argument about conspiracy is interesting because they're going to argue that it's not subject to TCPA, or in the alternative, even if it is subject to TCPA, that he met his burden. But ultimately, some other underlying tort has to succeed for the conspiracy to be allowed. Because if all of the other claims are dismissed, the conspiracy can't stand on its own. So this is just, I'm only pointing out that this is a little different, okay, than the other claims. Oh, and by the way, I did a short video on point of error 1, the defamation claims. I did a short video on that earlier today. You should go check it out. And the reason I say you should go check it out is because those videos are different than what is said on the show here. right? They're supplemental to it. They are, I don't know how else to word it. They're an accessory. It's a separate set of thoughts about the thing. It's not just a rehash of what's covered on the show. It's not just a read through or anything like that. It's my take on the strategy involved. So if you didn't get a peek at that show, go ahead and do it. They're much shorter. You know, they're about 10, 15 minutes. I think that one was 13 and a half or something like that. So you can go check out that video and watch for the other points of error to be incorporated into smaller videos like that as well. I find that people who don't have time or whatever to sit through a live stream tend to enjoy those short videos. And they're a little more shareable and stuff like that. So you can check that out if you want to. I recommend it, but you know, it's more up to you guys to recommend it if you like it. If you like that stuff, let me know. If you hate that stuff, let me know. All right. So the trial court erred by dismissing Vic's claim of civil conspiracy against appellees because A, his conspiracy claim is not subject to dismissal under the TCPA, and B, Vic nonetheless established by clear and specific evidence a prima facie case that appellees conspired to harm him. This is, again, for this to survive, they're assuming that some of their other claims will survive, okay? Vic's conspiracy claim is not subject to the TCPA. Vic's conspiracy claim is not subject to the TCPA because the TCPA. I cannot speak today. Oh my gosh. Look, my cousin's going to jail again. Oh well. I'm gonna kill a judge's kid. That's the Cuckmote 5000 or whatever. Vic's conspiracy claim is not subject to the TCPA because appellee's actions were not in furtherance of a protected common interest. This court has previously held that the TCPA's protected right of association. So if you remember, the TCPA is designed to stop the suppression of free speech and free association, right? Protected right of association, quote, requires the expression, promotion, pursuit, or defense of common interests, which implicate more than the narrow, selfish interests of persons who act jointly to commit a tort. All right? So, if I and one other person have some interest for us, it may be common, maybe a common interest between the two of us, but we decide to enact some tortious act against someone for the purpose of that common interest. That's not a common interest of association that the TCPA is protecting, according to this suit. According to Kawak versus Antero Resources Corporation, they're suggesting that the common interest must be the common interest, like the greater good, not just my greater good, right? It's a recognition of a community interest, we'll say, not just between the tortfeasors themselves. All right, that's what we're going for. So what their argument here is basically saying is that they weren't helping the community. They weren't making public statements about public events. They were making public statements about private disputes between Vic and the parties. And they were. Jamie Markey's discussion is about Vic allegedly grabbing her hair and whispering something sexual into her ear. That's what her beef is with Vic. Her issue about these safety of fans at conventions, that has nothing to do with, even if you take the idea that he did this thing, that has nothing to do with fans at conventions. That's a private issue between Vic and Jamie Markey that would be resolved by police or would be resolved by a civil court action between those two. It has nothing to do with anyone else, right? That's the argument here. No, of course, Jamie Markey is lying because the bitch can't speak without lying. Flat out. Like, that's just how it goes. She lied for clout. She lied for prestige. She lied for the in-group or whatever it was. And she lied for the purpose of increasing her own aims. That's it. That was the goal of the lie. Her aim was to name and shame Vic, to have him removed and blacklisted from the industry for whatever selfish reason she had. That's what it was. Okay? So that's a personal interest, not a public interest. And that's the issue. That's the issue. In order to trigger protection under the TCPA, i.e. before a plaintiff must present a prima facie case, it is the defendant's burden to show by a preponderance of the credible evidence that they were acting in concert to promote, pursue, or defend an interest common to the public or a group larger than themselves, not merely their own selfish concerns. And that's, again, citing back to this Kawkak versus Antero Resources. Now, we also have a footnote here. Civil conspiracy is not an independent tort, rather being derivative. It is entirely dependent on the injury caused by the underlying tort. As a derivative tort, it survives alongside the underlying tort. So basically, if the defamation, tortious interference, if those claims come back, then the civil conspiracy comes back. That's the argument they're making. All right. When a legal action is in response to both expression protected by the TCPA and other unprotected activity, the legal action is subject to dismissal only to the extent that is in response to the protected conduct, as opposed to being subject to dismissal in its entirety. Hence, the TCPA is not a shield against conspiracy merely because defendants claim they were pursuing their common interest. Instead, in order to enjoy the protection afforded by the TCPA, defendants must show by a preponderance of the credible evidence the larger common interest that their conduct was promoting, pursuing, or defending. So they're arguing here that if I simply said it a second ago, but let's get a little more complicated because lawyer, right? If those underlying claims of defamation or tortious interference were to survive, this should be brought back because they did not ever make the argument that the TCPA applies to civil conspiracy in this case by a preponderance of the evidence. The defendants, I don't believe, argued at all this point of law about the common interest of the community in regards to the civil conspiracy being dismissed. They merely relied on the dismissal on the grounds that the other parts were being dismissed. So that's a little bit of a gamble, because if the other parts are not dismissed, then the civil conspiracy will survive as well, unless you independently argue and get it removed. My memory is not perfect, but I do not believe they had an argument sufficient to establish a common interest in the portion that was being alleged, in the statements that were being alleged and the claims that were being alleged. In fact, how could they? They claimed that nothing said was possibly defamatory at all. That was their argument. Okay. At the outset, Appellee's public comments referred to events that, if they had occurred, would have been a private matter between complainants and Vic. They did not involve the interests of any group or the public. Indeed, Appellees showed no correlation between their comments, alleging assault, harassment, or threatening behavior in private settings, and the public comments they referenced, alleging over-friendly, over-affectionate behavior at conventions. So, and of course, there is no correlation between them because one of them is a criminal activity and the other one is nonsense. Can I be any more clear about that? Over-friendly, over-affectionate behavior at conventions is literally how conventions occur. Like, that's just how conventions are. And I've only been to a couple, and it's plainly obvious that people there are over-friendly, over-affectionate. You're meeting complete strangers. But we short-circuit the fact that you're meeting up with complete strangers because you share some sort of commonality in the hobby that you're engaging in, be it cosplay, anime, comics, sci-fi, Star Trek, Star Wars, whatever it is, Golden Girls, it doesn't matter. You know, you skip that icebreaker step, you skip the awkwardness because you just say, hey, you like this thing, I like this thing, we already know that this commonality occurs, so you can safely walk up to someone and say hi and know that you've got something to talk about. It's the short circuit to human interactivity that's really, really convenient and why a lot of people go to conventions. It breaks down walls that they have trouble getting through already. Not to play on the social stigma, but there is a social stigma related with geek community and conventions because, let's face it, lots of people in geek communities have some level of social anxiety or social awkwardness that doesn't fit well outside of their communities. They haven't, they're not always well adjusted to conversation amongst strangers. So these safe places allow them to engage in those conversations, and it just gets past that initial trouble that a lot of people have in social interaction. Okay, self-included, right? Like if I just meet you in public randomly and we have no commonality, like I'm not going to remember your name. We're not going to have something to immediately talk about. It'll take some work on the part of one of us to make that conversation happen. At a convention, you come up to me and say, hey, you like anime? I like anime. That's cool. What anime do you like? Done. We already know that we like anime. Otherwise, why are we at an anime convention, right? That's the short circuit I'm talking about. That's this over-friendly, over-affectionate behavior at conventions. Literally, the purpose of conventions is over-friendly and over-affectionate people. Like, that's why they exist, is so that you can come in commonality. Oh, God. I think is that just bukkake? Is that what that is? So you just come together in commonality over a shared hobby or experience. Okay? Way different from assault, harassment, and threatening behavior. Very, very different. Rather, appellees attempt to make their accusations into a public matter via social media. Right? That's what their goal was, and that's true. These are things that, by all accounts, if they occurred, are much better dealt with through any channel other than Twitter. Right? HR departments, police, complaining to convention staff, having documentation of what sort of harassment, assault, or threatening behavior occurred, if it's at a convention. Shockingly absent from all of this. Instead, they went to Twitter where they can filter the responses, where they can omit facts, where they can be completely free from the objective burden of telling the truth, and where there is no potential for retaliation outside of a very complicated defamation lawsuit. That's where they went. Why? Because that's where you go when you're a coward. Okay. Appellees provided no evidence, or at least factually insufficient evidence, that what they alleged happened between them and Vic in private was a common interest shared by the public at large at or before the time of publishing their tweets. Now, they're going to fight back against this. They are. I mean, they're going to fight back against every single point. I got a comment today on my short video saying, like, if I'm pointing out this stuff, isn't it going to be used by the defense? No. I mean, what I'm doing here is not doing a legal analysis and rewriting, writing a response brief for the appeals court. What I'm doing is trying to translate into regular people words this stupid miasma of the law. And that's what gets kind of lost in all this stuff. Is my goal is so that you guys or whoever watches this show walks away from these documents understanding what is going on in the document. My goal is not that you will go on and write a law review article on this, or that you will go to win the case. So I'm pointing out some basic stuff about this. I'm giving my thoughts on strategy behind some of the stuff, and really just trying to translate it here. That's the goal, is for the understanding of people who are watching the video. I'm not giving away anything that the other side is going to be able to, like, aha, and if I am, they should honestly turn in their bar cards, find a bridge, and jump off of it. Because they shouldn't be lawyering if they're relying on my YouTube analysis, which, by the way, they can never decide if I'm the stupidest person on earth who doesn't know anything about law, or if I'm giving away the secrets of the plaintiff for the defense who never thought of them before watching my show. But it's a ridiculous idea that I'm somehow giving them ammo or pointing out something that they hadn't thought of. That's not the case here. They will write what they will write, and they're going to attack all of this stuff. What they're going to attack specifically on Ron's is they're going to try and differentiate, and this is a good thing for Vic. Okay? When they make this argument, this will be great. If they make the argument that some of Ron's comments are not involving private behavior between Vic and Monica, for example, but they're involving this public concern. Yeah, go ahead. Go ahead and argue which tweets involve that common interest and which tweets involve private matters. Please write that argument down in the suit. That would be great. That would be fantastic if they just go ahead and start citing to the tweets and saying, no, these are common interest things. Just point out to the court that you made the statements. Wonderful. I will relish that. That'll be great. All right. Moreover, the trial court made no finding of a larger common interest that appellees were promoting, pursuing, or defending. Rather, the trial court focused solely on Vic's prima facie case of conspiracy. Vic claimed that appellees acted together in a conspiracy to defame him and interfere with his contracts and prospective business relations, i.e. the endpoint of their conspiracy was to destroy his career. Now, criticism I have of Ty's performance, and I'll mitigate it by saying that Judge Chupp wasn't interested in hearing this, and I think this is a big problem with how the TCPA hearing went in general, is right here. This sentence needed to be said over and over and over again at the TCPA hearing. Again, in fairness to Ty and An Lee and the whole team, Chupp wasn't listening like this, and he went through the TCPA claims in his order and didn't want to hear about stuff out of order. He said it. He's like, no, I want to hear about this. I won't hear about this. Well, I'm sorry, Your Honor. The whole point is that there is a conspiracy to destroy the guy's career. This is my, again, it's a mild criticism, because if you're in that courtroom, and I know some of you were in there with me, it would have been really difficult to get Chuck to hear this line. But I think if they could have maybe gotten in front of it with this summary and hammered it home over and over, they're in a conspiracy. All of this is calculated to destroy his career. And then with the addendum, and they did. And they did. There's a storytelling aspect to lawsuits. And I think maybe some of the story of Vic got lost in here. And this is not a criticism. These are choices that are stylistic that some lawyers make and other lawyers don't. And I think that it would have at least been different to really try and tell the narrative of what happened to Vic. But again, more of the criticism stuff here. When you open up the lawsuit or your hearing arguing about bullshit notary issues on withdrawn affidavits, and then the procedural addition or non-addition of the second amended complaint and then unsworn declarations, when you open it up with that, because that is where you ended up leaving off, it gets really hard to tell the narrative story, right? The tone is set by this procedural argument over nothing, over these little things that don't really matter to the story. And that worked out really well in the defendant's favor and worked really hard against Vic. And again, that's sometimes just how it goes. That's how Chuck wanted to do the hearing. And I think that really got in the way of a lot of stuff. But integrity and honest analysis involves saying, being critical where it is due. And I think that is a place where I can be pretty critical of how it was taken. This story, and I can pretty much guarantee you Ty would agree, that this story did not get told well enough at the TCPA hearing. It got told better at the fee hearing. It got told better when Vic was on the stand at the fee hearing than it did at the TCPA hearing. So hopefully they'll get a chance to tell the appeals court that, a little bit more clearly. However, appellees provided no evidence, much less factually sufficient evidence, that destroying his career was a common interest shared by the public, nor could they. The evidence which Vic provided showed that the public opposed appellees' aim to destroy his career. This is footnote 40. I don't know what this is. Okay. Let's go. Oh man, now I got to get back. We're on page 40, I think. Yeah. Furthermore, appellees have vigorously denied acting together. Appellees failed to show that the TCPA applied to Vic's conspiracy claim, and the trial court's dismissing his claim is reversible error. So, with the caveat addendum that assuming arguendo, at least one of the other underlying civil torts follows, is reversed and goes through. So, I should note that I do have the clerk's record now, so I could pull this stuff up, but it would take a bunch of time to do so. I'm gonna see. I don't know how exactly to use the clerk's record yet, but if you guys have any ideas, let me know. But I did get a hold of it. All right, we've got Sierra Mike 091 says, when I left 6 months ago, I was but a simple specialist that hadn't even graduated basic combat training. Now I return a newly commissioned second lieutenant in the Minnesota Army National Guard. Now enjoy some of my new O1 pay provided by your tax dollars. Hey! Gracias, Sierra Mike. Happy to have a return of those tax dollars. I appreciate that very much. I've got a relative in the National Guard, in the Minnesota National Guard, and hopefully you meet him sometime. I bet you guys will get along just fine. So use the clerk's record very carefully. We'll see. Next, we've got Chef Koji. It says, hypothetically, say Vic wins on all the appeals, then wins in court, and Monica, Funny, and Jamie are ordered to pay X amount of dollars. What's to stop them filing bankruptcy so they never pay a cent? Also, estimated time on appeal ruling. Well, what's to stop Jamie and Monica and Ron from filing bankruptcy? Nothing. Nothing at all. What's to stop Funimation from filing bankruptcy? A whole lot. The fact that a lawsuit win against Funimation for Vic would not put them into bankruptcy, most likely. Would not make them insolvent. They have a parent company that is worth billions of dollars. So they would be able to probably pay out whatever amount is awarded. The other part of that would be is if he wins on all counts, Funimation would be responsible for Jamie and Monica's words as well, because that would be the the vicarious liability claims as the employee or employer of Monica and Jamie being employees. So the bulk of, if he won on every single issue, which is, it's not outside of the realm of possibility, but if he did win on every issue, then the bulk of that would actually fall on Funimation's shoulders. And Funimation isn't going to be filing for bankruptcy because they would have assets that would be collected by creditors, like a studio, a bunch of equipment, computers, all sorts of stuff, inventory of all of these DVDs and stuff like that could be auctioned off. But they wouldn't have to, because they have a parent company that has plenty of funds to support it. So hope that answers your question. There, estimated time on appeal ruling. Well, the response to the appellant's brief is due, I think March 10th, something like that. And then there would be a reply to that response. That would be another 20 days out. So we're looking at the end of March, maybe very beginning of April. And then the ruling can take a long time. Really depends on if the court wants to hear oral argument or not. But yeah, plus we've got the cross appeal stuff coming in, and there'll be a response and then a response to that as well. Earliest, you're talking late May, early June, maybe into July. Latest next year. I mean, latest technically 2 years out, probably not. I think summertime we'll have a response, or we'll have some answers on the appeal, on the ruling. But it's a ways out, guys. All right. So next, like I said, I mean it this time. The case is going to slow down here. This is the appeals court. All of the little back and forth shenanigans of the district court, those distractions go away, and it's really just brief, wait, ruling. Someone said at this rate, the GoFundMe will be over 400K. I mean, it's certainly a possibility. Let's check it now. We are at $275,880. Thank you to Anonymous. And I don't think I thanked Travis Curtis or Tamara Holloway last stream, but thank you guys for your donations. Very, very helpful. Every single dollar is helpful. And yes, Vic's GoFundMe is still there and still helpful in every way. You know, this is expensive, very, very expensive, and yeah, it's great when someone can come in and crush your career, and then your only real remedy is to file a lawsuit that costs tons and tons of money. So, but your career was crushed, so you don't have your income. So that helps, right? That's always wonderful. Thank goodness Vic is also getting convention appearances still, but even so, you know, that's it's a fun prospect. Okay, so nonetheless, even if this court finds that Appellee's accusations were furthering a common interest, Vic's claim for conspiracy should not have been dismissed because Vic established a prima facie case. Vic showed by clear and specific evidence each essential element of his claim that Appellees conspired to defame and interfere with his contracts and prospective business. He was required to produce the minimum quantum of evidence supporting a rational inference that 1. Two or more appellees. 2. Seeking to accomplish an object or course of action. 3. Reached a meeting of the minds on the object or course of action. And then 4. Then took one or more unlawful overt acts in pursuance of the object or course of action. And 5. Damages occurred as a proximate result. It's citing First United Pentecostal Church of Beaumont versus Parker. A civil conspiracy claim may be proved by circumstantial evidence and reasonable inferences from parties' actions. Again, citing to Lipsky. Once the conspiracy is proven, each co-conspirator is responsible for all acts done by any of the conspirators in furtherance of the unlawful combination. So, the interesting thing about civil conspiracy is that, let's see, not everybody involved in the conspiracy has to do the thing. Does that make sense? They don't all have to do, they have to do one or more things, but they don't have to do the main thing. So whoever's involved in the defamation, they don't all have to do the defamation. They just all have to take one or more overt acts in furtherance of the unlawful endeavor, which would be defamatory endeavor. And then once that happens, they're each responsible for all of the acts done by any of the parties. So pretty cool how it kind of just like, look, you're all an entity that is involved in this and you're all responsible, is how that works. Vic showed that appellees engaged in a coordinated effort with the goal of, quote, naming and shaming, so that Vic was, quote, blacklisted and, quote, out of work. I'm going to guess that I know this one is Jamie Markey, and that this is probably Ron, and this is probably Monica. Something like that. Maybe these were both Ron, I don't know. He showed that Monica's allegations initiated Funimation's investigation, and that Funimation kept her updated about its confidential internal investigation. So there's an alleged conspiracy between these two. He showed that Monica asked Funimation what she could say publicly, and shortly after those discussions, Ronald and Monica told Christopher Slatosh that Funimation was conducting an investigation into allegations against Vic and that criminal charges would soon be filed. And Ronald maintained a continuous barrage of tweets accusing Vic of assault. He showed that Ronald and Monica publicly urged Funimation to make a statement about Vic. And in an orchestrated response, Funimation tweeted that its internal investigation determined Vic had engaged in threatening and harassing behavior. This orchestrated response, again, I'm guessing on some of these footnotes, but, when Monica and Ron had both pressed for Funimation to make a public statement about Vic, something that they had not done initially, and then they did. So what they're doing is trying to say, look, we have to believe that they're all in on this. Look at how this worked out. Look at how they coordinated this. Look at how Monica and Ron, independent contractors that Funimation claims they have no control over, no relation to, other than their independent contracts. None of that were able to force Funimation to make a statement about Vic that they otherwise weren't going to make and didn't have to make to affect the termination of his contract. They didn't have to do any of that, but they chose to do it that way. And so the inference is, well, look, these people who are all involved in the same aims, who were involved in Funimation as well, they demanded it, and then Funimation responded to them. Kind of looks like this is organized. That's what they're going for here. Which Monica signal boosted with her description of multiple investigations involving dozens of participants and of Vic as the very definition of harassment. The reasonable inference drawn from their actions is that Funimation, Monica, and Ronald conspired to defame Vic by falsely proclaiming that Funimation determined he had assaulted, harassed, or threatened women. Not only were these statements defamatory per se, for which damages are presumed, but Vic also showed that he suffered actual damages as a result. Vic also showed that prior to their defamatory tweets, Monica and Jamie had discussed how to harm Vic in a private Discord server. Not long after their discussion, they published virtually identical stories of Vic grabbing their hair, yanking their heads back, and whispering something sexual in their ears, and of witnessing him do this multiple other times. In the interim, before and after their tweets, Ronald repeatedly tweeted that Vic had assaulted 4 of his friends, whom he later testified included Monica and Jamie and countless others. The reasonable inference drawn from their actions is that Jamie, Monica, and Ronald conspired to defame Vic by falsely proclaiming that he had assaulted numerous women. Not only were these statements defamatory per se, for which damages are presumed, but Vic showed that he suffered actual damages as a result. How did people find the Discord posts? That was, if I'm not mistaken, those Discord posts were linked or leaked by someone who was in that Discord, and then they changed their mind about Vic. So that's that. Vic thus established by clear and specific evidence a prima facie case that Funimation, Monica, and Ronald conspired to defame Vic by falsely proclaiming that Funimation determined he had assaulted women or engaged in threatening and harassing behavior, and a prima facie case that Jamie, Monica, and Ronald conspired to defame Vic by falsely proclaiming that he had assaulted Jamie and Monica. Hence, the trial court's dismissing Vic's civil conspiracy claim is reversible error. And you know, the thing is, the thing about this is a bolstering argument for the court, right? Here we go. It's another chance to hammer home the defamatory nature of their actions, right? So yeah, they're arguing for the civil conspiracy here, but again, it tells a story. Look what they did, and we showed not only that they did this, but that they did this together. We showed all this. It's all here. And this thing was tossed out. It shouldn't have been tossed out. The trial court's refusal to consider appellant's second amended petition is reversible error. The TCPA requires a trial court to, quote, consider the pleadings and supporting and opposing affidavits stating the facts on which the liability or defense is based when determining whether a legal action should be dismissed. However, the trial court refused to consider Vic's second amended petition because it was filed within 7 days of the hearing on appellee's motion to dismiss under the TCPA. The trial court focused instead only on Vic's amended petition and his response to appellee's motions. Trial courts refusing to consider Vic's second amended petition constitutes reversible error. Generally, a party may amend its pleadings freely, but any pleading filed within 7 days of the date of trial requires a trial court's permission, which shall be granted unless there is a showing of surprise by the opposite party. Indeed, the trial court has no discretion to refuse an amendment unless 1. The opposing party presents evidence of surprise or prejudice, or 2. The amendment asserts a new cause of action or defense and thus is prejudicial on its face, and the opposing party objects to the amendment. Now, there were no new causes of action or defenses presented in the second amended petition, so they're citing to an authority here from Fort Worth Court of Appeals. So from this very court, that says that the trial court has no discretion to refuse an amendment unless these things are present. evidence of surprise or prejudice, or the amendment asserts a new cause of action. So they didn't assert a new cause of action or defense. That's very simple to get in. Evidence of surprise or prejudice will be the question there. They're going to say the opposing party didn't do that. Obviously, the opposing party is going to come back and say, no, it was surprising, even though we discussed everything from the second amended petition and the unsworn declaration. We discussed all of that in our responses. It was still a surprise to us. So that's citing, Crosstex North Texas Pipeline, LP versus Gardiner. Not Gardinier, that'd be French, and there would be an I in there. The allegations and claims in Vic's second amended petition were the same as those in his original petition and his amended petition. The facts stated in and the exhibits attached to Vic's second amended petition were consistent with and complementary to those stated in and attached to his response to appellee's motions to dismiss, belying the claim of surprise by appellees. Now, they're going to come in and say those affidavits were withdrawn. But of course, they responded to the notion of the affidavits in there, and the unsworn declarations are substantially identical to the affidavits. So what's happening here is the appeals court is going to be presented with this dilemma. Do we dismiss a potentially meritorious lawsuit over a procedural issue with the filing of the unsworn declarations and the affidavits? Because if the argument is these shouldn't be included, well, why not? Like, why not? Why shouldn't they be included? You can't argue surprise over the affidavits. If you're arguing that they shouldn't be included because they were withdrawn, it's on the record that they were withdrawn for a form error, and it's on the record that Ty asked specifically to replace those affidavits with the unsworn declaration. That's all there, and said that they're identical to the other ones. They're just unsworn declarations versus the versus affidavits. So they can't really argue surprise. So it kind of puts them in this weird catch-22 where they have to argue that evidence that might show that there's a prima facie case should be excluded. Only strictly on procedural grounds, not because the evidence is inadmissible, because they're arguing to the method of admissibility. The appeals court's going to have to look at that and say, man, we got to look at these things. They don't want them in. Why? And then do we prejudice a plaintiff by dismissing his entire cause of action over this procedural issue? The TCPA isn't there to win by procedure. The TCPA is to prevent meritless claims. If he shows merit, and we're going to do this over less than a business day of difference in time. That's what we're going to do. And we're going to go against the amending of the petition. For what? That's the strategy here. That's the goal here. And that's what what the appeals court is going to be faced with, is this choice. So this is actually kind of interesting how they're setting this up. And I'll be really interested to see how defendants want to come tackle this argument. The defendants are going to have to tread very carefully in their response, because if they make any sort of notion that the inclusion of the second amended petition or the inclusion of these unsworn declarations is damaging to their case, they risk telling the appeals court that this should go on other than this procedural issue. Because the appeals court can probably find a way to get around the procedural issue. They have sufficient language in the rules and sufficient findings in their own court to allow the second amended petition here. They have it. That's going to be really interesting to see how the defense handles it. I'm looking forward to it. Therefore, the trial court had no discretion to disregard Vic's second amended petition in conjunction with his response to Appellee's motion, Texas Rule of Civil Procedure 63, and then Gardner. The trial court's refusal to do so is reversible error. And then we have a footnote here that's a little bit long. The trial court indicated that considering Vic's second amended petition might be contrary to the rules of civil procedure. However, this court considered a similar situation wherein the plaintiffs filed their second amended petition prior to the hearing on the defendant's TCPA motion to dismiss, and that's DeAngelis versus Protective Parents Coalition. Citing Texas Civil Practice and Remedies Code 27.006A, this court considered the second amended petition in its TCPA analysis. See also Transdesign International LLC versus SAE Towers Limited. Quote, the trial court noted that the TCPA did not prohibit the trial court from considering a late filed pleading. So here we have the Texas Court of Appeals in Fort Worth on DeAngelis versus Protective Parents Coalition. And then we have the Texas Court of Appeals in Beaumont on this other case. Both circuits, and most importantly, the Fort Worth circuit, coming to the same conclusion that a late filed petition should be considered for TCPA purposes. And that, that is very, having this Fort Worth one is critical. So it'll be interesting to see how they handle it, right? Okay, back to this. Appellees did not satisfy their evidentiary burden because the trial court should have struck the evidence attached to their motions to dismiss. So this is going back to the big filings that they made during the TCPA time, where they tried to strike all of the evidence brought in by the defendants. Nixhex says, have you thought about doing a series of videos on TAI like you did with defamation? It pops up in the most iconic cases you have covered, like the lawsuit, your boy Zach, and the Vic case, as well as cancel culture as a whole. I mean, I have thought about it. I don't know. I'll think about it. The problem is, here's the problem with doing these video series on individual things, okay? Is that they get very state specific, and then translating legalese into common, sort of a common understanding is a very frustrating endeavor, because the law system doesn't work on a common understanding, right? It is highly specialized, and the language really matters as far as when you go after something. So when you try and distill something down into its simple form and explanation, it can be very confusing to people, because they think that, well, this always applies, or this is how it is, or again, that we're trying to write a law review paper here. So I don't know. It's a thing that has to be kind of delicately handled. But I'm not opposed to doing it. I just have to find the right way to do it. Okay. So we're on point of error 7. The dismissal of all of their evidence during the TCPA. Vic moved to strike much of the evidence submitted by appellees in their motion to dismiss because it was inadmissible under the Texas Rules of Evidence. The trial court denied Vic's initial motion to strike Funimation's inadmissible evidence. Yeah, Chup just denied it out of hand. It was great. By its October 4th, 2019 order and its final judgment, the trial court implicitly denied Vic's other motions to strike appellee's inadmissible evidence. Thus, the trial court considered inadmissible evidence supporting appellee's motions, which caused the rendition of an improper judgment and constituted reversible error. Texas Rules of Appellate Procedure 44.1. What is that rule? I want to see that rule real quick. Go 44. So it's just a standard reversible error in civil cases. Standard for reversible error. No judgment may be reversed on appeal on the ground that the trial court made an error of law unless the Court of Appeals concludes that the error complained of, 1, probably caused the rendition of an improper judgment, or probably prevented the appellant from properly presenting the case to the Court of Appeals. So basically they're just saying this caused the rendition of an improper judgment. There's the clue. Rendition of an improper judgment. So good job. All right. I just wanted to see exactly what that law was, what the rule was, if it was specific to evidence or if it was more general. It was more general. Funimation's motion to dismiss evidence. Vic objected to paragraphs. This is worded weird. This looks like Funimation's motion to dismiss evidence rather than evidence or motion to dismiss Funimation's evidence. I would have rewritten that because I think Funimation did have a motion to dismiss evidence in there. I would have written it motion to dismiss Funimation's evidence. Minor critique. Vic objected to paragraphs 5 to 7 and 9 of the affidavit of Karen Mika attached as Exhibit A to Funimation's motion to dismiss. I think these are all just boring citations. Paragraph 2 of the affidavit of Tammy Denbo, attached as Exhibit B to Funimation's motion to dismiss. Paragraphs 5, 6, and 8 of the affidavit of Scott Barretto, attached as Exhibit C to Funimation's motion to dismiss, and Exhibits D through W attached thereto. Ms. Mika's affidavit did not affirmatively show how, as Funimation's vice president of operations, she obtained personal knowledge of the facts alleged in paragraphs 5, 7, or 9, and thus failed to provide the proper foundation for relevance and admissibility. So that's Texas Rule of Evidence 104B, and citing Cunningham versus Zurich, which is a Fort Worth Court of Appeal ruling. And this is pretty important in Texas because in some states, all of the appeals courts are considered authoritative. In Texas, only the appeals court of the relevant county is authoritative, and the Supreme Court, of course. But then the others are merely persuasive. So having conflicting rulings, the one in the district will win out. And then citing Barham versus Sugar Creek National Bank, and that's from Houston. In the 5th, 6th, and 7th paragraphs of her affidavits, Ms. Mika testified about statements made by others, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. So that's Rules of Evidence 801D and 802. Also, paragraph 5 of her affidavit references, quote, negative Twitter posts and other sources within the anime community, in addition to being inadmissible hearsay. She should have attached the actual allegations, properly authenticated, rather than summarize their content. So, they're arguing, this is like a best evidence argument. They could bring up the actual allegations. They could authenticate them. She could authenticate them. I, Karen Mika, on this date, found this thing. Here's the screenshot of it. I pulled it up, and to my knowledge, it is true and accurate and correct replication of the original, blah, 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 blah. But she summarized the content, and they're, now it's hearsay. Finally, Ms. Mika's testimony in the 9th paragraph of her affidavit constitutes legal conclusions regarding questions of law, agency, authority, and liability on which she was not qualified to testify. So that's Texas Rule of Evidence 701. Lemon versus State, that's a criminal appellate court. Greater Houston Transportation Company versus Phillips, which is a Texas Supreme Court. Boyd versus Texas Christian University, and that's the Fort Worth Appeals Court as well. So they ran the gamut there. Good job. In the 5th sentence of Chapter 2 of her affidavits, Ms. Denbo testified about statements made by others which are offered to prove the truth of the matters asserted, which is inadmissible hearsay. Further, her affidavit failed to establish her personal knowledge of these matters and thus failed to provide the proper foundation for relevance and admissibility. So again, citing some of these cases. In the 5th and 6th paragraphs of his affidavit, Mr. Barreto testified about statements made by others which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. In paragraph 8 of his affidavit, Mr. Barreto merely testified that exhibits D to W to Funimation's motion to dismiss were true and correct copies, without any testimony that he is a custodian of records or otherwise has any requisite personal knowledge to establish what each exhibit is, and thus failed to establish the requisite predicate for authentication of Funimation's exhibits. And that's more rules of evidence in various cases as well. Funimation relied on this evidence to prove that Vic is a public figure and that its tweets related to a public controversy. Because the trial court failed to sustain Vic's objections, the trial court's findings that Vic is a public figure and that Funimation's tweets related to a public controversy are based on inadmissible evidence. The trial court's failure to sustain Vic's objection led to an improper judgment and is reversible error. So they're actually attacking the public figure and public controversy aspects of it. Winning that would be a critical blow to Funimation's case. Oh, here we go. Here's some interesting footnotes. I mentioned the best evidence rule. We have it here. Alternatively, under the best evidence rule, Mr. Barreto was required to attach the actual inquiries referenced in the first sentence of paragraph 6 rather than summarize their content. And then here we have, moreover, exhibits E through I, K, M, and O through W to Funimation's motion were all hearsay. Each was an out-of-court statement made by someone other than Mr. Barreto, which are offered to prove the truth of the matter asserted therein, and hearsay is inadmissible. And then finally, we have this footnote. In fact, Monica and Ronald relied on Miss Mika's affidavit and Miss Denbo's affidavit too. So attacking those in the public controversy and public figure things would be, again, it'd be devastating if the Court of Appeals overturned the finding that Vic was a public figure. I don't know that they will, but if they do, if this thing goes back and they overcome the public figure and public controversy rulings, they'll be just dead in the water. They will have no possible defense. It'll be funny. It would be very, very funny. I am not holding out hope for that, but it would be really great to see. Funimation thus failed to establish by a preponderance of credible evidence that the TCPA applied to Vic's claims against it, and the trial court's dismissing Vic's claims against Funimation is reversible error. So they went after the public figure status of Vic, generally speaking, and specifically the dismissing Vic's claims against Funimation based on their inclusion of and the court's reliance upon Funimation's inadmissible evidence. And they're going to do the same with Monica and Ronald, and probably with Jamie Markey in just a minute. Vic objected to exhibits 1 through 13, 15 through 18, and 22. Attached to Exhibit A of Monica and Ronald's motion to dismiss, the affidavit of Robin Michelle Blankenship Carroll. Exhibit B to Monica and Ronald's motion to dismiss, the affidavit of Kara Edwards. Exhibit C. The affidavit of Lynn Cunt. Exhibit D. The affidavit of... Freud has got me. The affidavit of Lynn Hunt. My apologies. The completely mentally stable and wonderfully warm and certainly not at all prickly cold bitch Lynn Hunt. The affidavits of Faisal Ahmed. Let's not do that joke. That's the kickoff a YouTube joke. The affidavit of Mary Reese, the affidavit of Whitney Falba, the affidavit of Naisha Perry, the affidavit of Adam Sheehan, the affidavit of Kelly Loftus, the affidavit of Michelle Specht, the affidavit of John Prager, the affidavit of Sean Lemoyne, and the exhibits attached thereto, the affidavit of Monica Rihal, and exhibits Q and R are attached to Monica and Ronald's motion to dismiss. Exhibits 1 to 13, 15 to 18, and 22 are attached to Exhibit A of Monica's and Ronald's motion to dismiss are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. The affidavit of... So now we're going to go through all of them. The The affidavit of Robin Michelle Blankenship Carroll is not relevant or material to any issue in the case and is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion and is therefore inadmissible. It's also completely false. But that's the problem with affidavits. You don't really get to attack the truth of the affidavit unless you have evidence to impeach it. Which is really, really frustrating, because if you're willing to have some crazy lady in another state just simply lie, you can do that. Like, the risk is that she gets found out for lying, but how often do people get punished? There you go. Find out. They found a crazy person who's willing to lie about something 30 years ago. The affidavit of Kara Edwards is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion and is therefore inadmissible. Paragraphs 2 to 7, 10, 12, 14, 16 to 18, 20 to 21, and 23 of Miss Edwards' affidavit constitute inadmissible opinion testimony. So then we have a longer footnote here. These are the ones I like to read. Vic also objected to the exhibits attached to Funimation, and Monica's and Ronald's supplements to their motions to dismiss. However, the trial court indicated that it would not consider anything filed by appellees after the TCPA filing deadline. If any portion of the trial court's October 4th order or its final judgment relies on the exhibits attached to Funimation and Monica's and Ronald's supplements to their motion to dismiss, Vic asserts that the trial court's failure to sustain his objections thereto likewise constitutes reversible error. This is another case where Chup said, well, I'm not going to do that. And then may or may not have done it. We don't really know. It's good job, Chup. He just doesn't rule on things. Doesn't rule on it at all. Oh my goodness, excuse me. I got the yawns. Paragraphs 14, 17, 18 of Miss Edwards' affidavit and the exhibits attached thereto are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Affidavit of Lynn Hunt is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion and therefore is inadmissible. Paragraphs 2 to 10 of Miss Hunt's affidavit constitute inadmissible opinion testimony. Paragraphs 5 to 7 and 9 to 10 of Miss Hunt's affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. The affidavit of Faisal Ahmed is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion and therefore is inadmissible. Paragraphs 3 to 7 of Mr. Ahmed's affidavit constitute inadmissible opinion testimony. Paragraphs 3 to 7 of his affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Again, all of these affidavits have nothing to do. They have nothing to do with Monica's statements. They have nothing to do with Jamie Markey's statements, and they have nothing to do with Funimation statements. They will argue likely that they have something to do with Ron Toye's statements. That's what they're going to have to be stuck arguing, is that Ron is talking about hundreds of women, so he's definitely talking about Faisal Ahmed's personal experience with Vic. That's what's going on. That's what they're going to have to argue, is that these have something to do with them. Because obviously, what Kara Edwards has to say about an encounter she had with Vic has nothing to do with Monica saying Vic forcefully kissed me in 2007. That's not how that works, right? Even if he did grab Kara Edwards' hair and yank her hair back and teabag her right in front of everybody, even if he did that, it wouldn't have any bearing on how he acted with Monica or Jamie or Ron when he teabagged him, or Faisal Ahmed, or anybody else on the planet. These are individualized things, and you don't get to say that someone has a character for doing these things. You don't get to do that, because otherwise you could just parade in a bunch of people to say, Vic man bad, and then that would be enough. And this really is a problem that Chup had in this whole thing, is Chup admitted a bunch of irrelevant stuff in the form of these affidavits. None of these affidavits are specifically talking to any of the specific claims. Now, this is probably a strategic move by the defense, right? The defense has asserted that Vic didn't make any specific claims of defamation, right? That they didn't defame him at all. So if part of their whole thing was hands off, he didn't present anything, then if they came in and said, well, this is talking about this specific tweet that Ron made, then suddenly they're making admissions about what happened. But if they're unwilling to do that, then they shouldn't get to have the affidavits put in. And we all know what the purpose of these affidavits actually was. If it's not clear, these horrific assholes used the lawsuit to continue defaming someone that they were defaming. That's all. That's all they were doing. Why would they bring in Michelle Specht? What on earth does Michelle Specht's affidavit have to do with any of the allegations of Monica, Marky, Ron, or Funimation? None of them said, none of them were offering up, well, he was, he cheated on his fiance as like evidence that he shouldn't be allowed to a convention or that he should be blacklisted from the industry. None of that was predicated on how his relationship with Michelle Specht ended. All they were doing there was trying to make him look bad, period. Because their legal team is a pile of shit. That's it. I mean, that's it. They are the juice in the bottom of the garbage can that makes you want to vomit. That's Jay Sean Lemoyne. I mean, he has some of that in his lungs too, but that's actually his entire being. That's Casey Eric. That's Andrea Perez. That's how they handled this. What they did was they endorsed their clients utilizing the legal process to further defame someone that they were already defaming. That was the entire point of bringing in these affidavits, because none of them speak to the truth of the matters asserted in the defamatory tweets or the defamatory statements or the defamatory text messages. None of that happened. Ron wasn't relying on Kara Edwards' affidavit in making his statements to Kamea because her affidavit didn't exist and Ron likely didn't know her story until after this happened. That's the disingenuous nature of all of this. Anyway, here we go. The affidavit of Mary Reese is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion, therefore is inadmissible. It's also bullshit because Mary Reese took the picture of Kara Edwards where she and Vic were recreating a romance novel cover intentionally. She posted it on her own Facebook in a friendly way years and years ago when it happened. She's only now using it against Vic because she's also terrible. These people are terrible. Look at what they're doing. Kara Edwards is terrible. She took an interaction she had with Vic that was friendly and amicable and twisted it years later to hurt him. That's what her goal of her affidavit was. No problem with it at the time. Her friend Mary Reese, who took the picture, had no problem with it at the time. They posted it on Facebook, likes, all that fun stuff. Yay, love being there, blah, blah, blah. Everybody's friends for the next several years. Suddenly, it's a bad thing. They're terrible people for doing this. That's like, let's put it this way. You know the tradition of when you get married to someone or you're at someone's wedding and the bride and the groom, they cut a piece of cake and then they go to like eat the piece of cake, and then someone like shoves it, the bride or the groom shoves it in the other one's face and like makes a mess. It's like, ha ha ha, you got icing on your face. It's stupid, but people do it all the time. All right, let's say they do that. It's the wedding day. Everybody's shoving cake in everybody's faces. It gets smeary icing all over. They have to like spit out some cake, and they're laughing and giggling, and everything's great. 10 years later, they're getting a divorce. And in the divorce, we'll do the non-prejudicial way of doing this. The husband says, "That bitch tried to choke me to death with our wedding cake at the wedding reception. I was going to take a bite of the cake and she shoved it in my face." That's the equivalent of what Kara Edwards did here. It's obvious bullshit. It's obviously a lie. She has twisted a friendly encounter into something nefarious for the purpose of ruining someone. These people are awful. Awful, awful, awful. Next. Where was I? Paragraphs 3 to 15 and 17 of Miss Reese's affidavit constitute inadmissible opinion testimony. Paragraphs 8 to 11 of Miss Reese's affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matter asserted. Affidavit of Whitney Falba is offered as character evidence. Again, Falba's claims have nothing to do with this. Paragraphs 3 to 10 of Miss Falba's affidavit constitute inadmissible opinion testimony. Paragraphs 8 to 9 of Falba's affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Naisha Perry is character evidence to prove that Vic acted in a blah, 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 blah. Paragraphs 3 to 4 of Perry's affidavit constitute inadmissible opinion testimony. Paragraphs 4 to 5 of Perry's affidavit are out-of-court statements. This is all the same stuff. Adam Sheehan, I heard that guy's a catch you next Tuesday, but I don't know him. I don't want to read this. I don't like reading the same words over and over. Adam Sheehan is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion, therefore is inadmissible. Paragraphs 4, 7 to 8, and 10 to 11 of Sheehan's affidavit constitute inadmissible opinion testimony. Paragraphs 4, 6 to 8, and 10 of Mr. Sheehan's affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Finally, Mr. Sheehan's testimony in the 5th paragraph of his affidavit constitutes legal conclusions regarding questions of law, agency, authority, and liability on which he was not qualified to testify. The affidavit of Kelly Loftus is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion, therefore is inadmissible. Paragraphs 3 to 5 of Ms. Loftus's affidavit, inadmissible opinion testimony, and 5 to 7 of the affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. The affidavit of Michelle Specht is not relevant or material to any issue in this case and is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion and therefore is inadmissible. They just flat out say that about hers. They should have also said, also, she's a vindictive bitch. The affidavit of John Prager is offered as character evidence to prove that Vic acted in accordance with a certain character or trait on a particular occasion and therefore is inadmissible. Paragraphs 3, 5, and 9 of Mr. Prager's affidavit constitute inadmissible opinion testimony. Paragraphs 3, 4, and 7 of Mr. Prager's affidavit are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. I'm going to get really good at saying this by the end. The exhibits attached to the affidavits of John Lemoyne, Exhibit P to Monica and Ronald's motion to dismiss, are out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Indeed, Mr. Lemoyne's affidavit is not relevant or material to any issue in this case and is therefore inadmissible. The affidavit of Monica Rial constitutes inadmissible opinion testimony and out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Exhibits Q. Oh, come on. Errant S in there. Errant S. Constitutes inadmissible opinion testimony and out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matters asserted, which is inadmissible hearsay. Exhibit S contains out-of-court statements made by someone other than the person testifying, which were offered to prove the truth of the matter asserted, which is inadmissible hearsay. Monica and Ronald relied on this evidence to prove that Vic is a public figure and that their tweets related to a public controversy. Because the trial court failed to sustain Vic's objections, trial court's findings that Vic is a public figure and that Monica and Ronald's tweets related to a public controversy are based on inadmissible evidence. Trial court's failure to sustain Vic's objections led to an improper judgment and is reversible error. Monica and Ronald thus failed to establish by a preponderance of the credible evidence that the TCPA applied to Vic's claims against them, and the trial court dismissing Vic's claims against Monica and Ronald is reversible error. Now, they didn't do one for Jamie here, and I don't know why. Maybe they didn't write. I don't remember if they filed a motion to dismiss Markey's evidence. Maybe they didn't. Because I think she just relied on their evidence, on Monica's and Ron's and Funimation's. I think that's why. Since she was using the discount lawyer and they were relying on the other lawyers to do work, I think that's why they didn't file a bunch of affidavits. They just went ahead and had their little piece. But I don't know. I don't remember. The trial court's ordering Vic to pay appellee's legal fees and sanctions is reversible error. Point of error 8. So this is a very short section. And it basically, I mean, this is just, you know, if you only pay if you lose and we shouldn't have lost, so we shouldn't pay, is how this comes out. TCPA provides for an order to pay legal fees and a sanction only if the non-movent's claims are properly dismissed. As shown, the trial court improperly dismissed Vic's claims against appellees. Accordingly, the trial court's order that Vic pay attorney's fees and sanctions is likewise improper and reversible error. Conclusion and prayer. Oh, and we're almost done here. So let's see how they wrap up this story. Appellees, in a concerted conspiracy to destroy Vic, published defamatory text, tweets, and email about him, knowingly interfered in his existing and prospective appearances at fan conventions, and he suffered monetary damages due to appellee's conduct, in addition to the damage to his reputation. When called to account for their tortious conduct, they sought protection behind the TCPA using inadmissible evidence, which the trial court improperly admitted over Vic's objections. However, Vic made a prima facie showing by clear and specific evidence of each claim he brought against them in both his response to their motions and in his second amended petition, which the trial court was required to consider but wrongly disregarded. In short, the trial court committed reversible error under Texas Rule of Appellate Procedure 44.1 by dismissing Vic's claims, refusing to consider Vic's second amended petition, failing to strike the objectionable evidence, and finding, based on inadmissible evidence, that appellees presented legally and factually sufficient evidence to satisfy their burden under the TCPA, and ordering Vic to pay appellees legal fees and sanctions. Vic prays that this court will reverse and vacate the trial court's October 4th, 2019 order and its final judgment, remand this matter back to the trial court for trial, and grant him such other and further relief this court deems equitable and just. So here we have the lawyer's signatures, certificate of compliance, all the form requirements. So it's 11,571 words, which leaves them approximately another 15,000, I believe another 15,500 words, 15,429 words specifically for their 27,000 word limit. That is rule 9.4H1. Let me double check and make sure that's 37 or 27,000, which I believe it is. 9.4H1. Oh! Documents listed below must not exceed the following limits. Brief and response in a direct appeal to the Court of Criminal Appeals. Okay, that's the criminal appeals. That doesn't seem, that seems like less words. A brief and response, 9.4H1. H2 has the, hold on. 2B. A brief and response in an appellate court other than a brief under than subparagraph A, and a petition and response in an original proceeding in the Court of Appeals, 15,000 words if computer generated and 50 pages if not. In a civil case in the Court of Appeals, the aggregate of all briefs filed by a party must not exceed 27,000 words if computer generated and 90 pages if not. Okay, so 15,000 words is the max they would get for this brief, and then they get 27,000 total. So in their reply, they get an additional 12,000 words, technically speaking, except a reply brief in appellate court and a reply to a response to a petition in original proceeding is 7,500 words. So they get 7,500 words, I guess. Yeah. Looks like their reply brief will be 7,500 words. Their total word count is 27,000 words, but it's 15,000 for this original thing. So they will get an additional 7,500 words, and they can petition for more, for an exemption to that if they need it. They're going to have a lot of... So what's going to happen is there's going to be 4 responses. Well, 3 responses. Monica and Ron, Funimation, and Jamie Markey. And they're going to have 7,500 words for each of those to come in. They're going to have to get an exemption to the 27,000 if they do 7,500 words for each of their responses. Now, they probably won't have to do 7,500 words for each of their responses, but they could. And they'd probably get an exemption for there being 4 parties. Like, we just need this many extra words, you know, for this, because there are 4 parties that we're, or 3 parties that we're dealing with. So that's, that is that. Then there it was served. Everything is fine. There you go. Woo! That is the appeal brief. So we are done with that. Thank goodness. I am tired of reading it. Oh. All right. Well. Oh my goodness. So what do you guys think about these this appeal brief? I mean, my overall thoughts on it are, I mean, they left 3,429 words on the table. That's not a ton. That's fine. I think they made the points they were trying to make. I've mentioned a couple things already that I would have done a little bit differently or would have added, and I think they could have been done in the word count, but they do have their responsive word count to consider, and so that's, you know, that will be that could be part of that. We'll see how it goes. Of course, they're really just banking on at least one issue coming back for each of the parties, if not all of the issues coming back for each of the parties, and that will be the ultimate victory, right? If each of the parties come in, or if each of the parties have something come back, then they won't have to deal with those contingent fees at all. And in fact, the fees that were awarded may be reduced even further. Nothing would make me laugh harder. Heck, if even one issue against one defendant comes back, I will be laughing all day. I mean, I won't be able to stop. I don't know what to do other than to laugh at that. That'll be just funny. So we'll have to see how that goes. Of course, we've got some time. They've got their reply brief, and then Vic will be able to respond to each of those. Insert clever name here. Says, given how bloated his original filings were, how big of an exemption do you think Das Lemon will need? Lemoyne is not writing. Here, let's get that off there. Lemoyne is not writing the appeal. Lemoyne is off of it. Rusty O'Kane is doing the appeal, along with whoever that senior partner was who yelled at Judge Chupp. I believe Hellberg. He'll be involved in the appeal as well, probably because I think he's the appeal specialist. But Rusty O'Kane is going to be handling the bulk of it. So I don't know if they'll need an exemption. They shouldn't. They shouldn't need an exemption for theirs. They do have a reduced word count. I think they only get the 7,500 words. Oh, I closed it, so I can't tell you off the top of my head. They don't get a full 15,000, but none of them should need a full 15,000. Again, they should just need the amount that they get, I would think, to respond to this, especially since most of this, no matter who it is, most of it applies to someone else because there are 3 parties. So, we'll have to see how they use it. I'm not entirely sure if they'll need any extension at all. But let's take one more peek at the GoFundMe. There were a couple donations that came in. We're up to $275,910. We've got Anonymous, Hunter, Chouinard, and Anonymous. Thank you guys for your donations. I read that Anonymous earlier. You've been double thanked, Anonymous. So there you go. Thank you guys for those donations again. Every one of them is appreciated very, very much. I mean, by Vic, I would assume. Not really by me. It's not like I don't get them. I'm happy that you guys donate, but I'm not going to feign that, like, if I say it's appreciated, people think it comes to me. It does not, obviously. It does not come to me at all. So yeah. Well, I guess we have kind of a short stream tonight. Maybe that's what we're doing. I think I don't have too much else to say on this appeal case. We've got a long ways to go, and we really just need to see what the replies do. I mean, I was kind of musing on the differences of opinion I might have as to what goes in. Like I said, I would have attacked the contingent fees just in case they're not able to prevail on any of the issues. I think attacking the contingent fees would be worth it. But that's me. That's my stylistic preference, and I'm not them. Also, not a Texas appeals expert by any stretch, so maybe I'm completely off base in going after that. The main trick here is pointing out that Chupp should have accepted the second amended petition. One thing I think they maybe will need to focus on, and it's probably going to come in response to one of the defendants making a stink about the unsworn declarations. They should really focus on, in my opinion, getting those unsworn declarations into clarifying that those should be a part of the record and that they should have been de facto admitted by Judge Chupp. And the fact that he doesn't ever speak of those in his order. Even in his final order, I don't think he disposes of those declarations. He never rules on Ty's trial amendment. Even though Lemoyne objected to it, he doesn't rule on the objection. So I think they should argue that Chupp admitted them by not striking them. They were admitted and should be part of it. I think maybe they should devote some time to that. But they may want to just avoid getting into a pedantic argument over the admission of those unsworn declarations and the affidavits. They may just want the court to, determine for itself if they're if they're properly admitted in the record or not, right? But we'll see. They may save some time for that in their responses. I don't know. I might have tried to shore them up independent of the second amended petition, but they're really, like, the bulk of the argument is second amended petition should be included, but even if it wasn't, we still made the case without it. And that's really important here because the case was made. The evidence was there. It's present not only in Vic's stuff, but it's present in the defendant's own filings. And if it's present in their filings, it should definitely be considered. And since that stuff is considered, then they should have passed TCPA. That's the argument they're going with. And that's the bulk of that whole brief, is those two key points. Now, the inadmissible evidence thing is a big section, and it's a big Hail Mary pass. I don't have a lot of faith in that section to prevail. I just don't think that the appeals court is going to go and override CHUP on abuse of discretion on the admission of evidence. Maybe they will. They typically defer pretty heavily to the district court on evidentiary issues. I don't think they're going to do it. But again, the trick is if they do, they win. So that's but I think if the appeals court does do this, they're going to reach it on grounds that the second amended petition should have been admitted. Therefore, there was sufficient evidence for this, this, and this. Maybe not sufficient evidence for this and this and this. We'll have to see how they handle it, but I think that's the approach the appeals court will take. I could be completely off base. Obviously, there's the possibility that the appeals court says, we admit all this stuff and still say that you lost. That's a possibility. Or, nope, the lower court was proper in its decision, which is, if they're going to blank Vic on everything, that's just how they'll do it. They'll say that the lower court was fine in how it handled stuff. And we'll just have to see. So, we've got X Setherin 2035 says, Nick, coming together in commonality, person named commonality, terrified and willing and wiping off brow sweat. Oh no. Watch out, commonality. You're in danger. You're in danger. So. All right, guys. That's what I got for you today. We're going to go through the super chats and justice chats that are remaining, but I think, I don't need to drag these streams out for 3 hours. So we'll wrap up a little early. We'll do a little Twitch thoughterly maybe, and we'll call it a night pretty soon here. So, if you do peace out during the reading of the remaining chats, thank you for joining. And we'll see you guys very soon. What do you guys just in the chat there, if you want to throw, I don't know, like the 1 for yes, 2 for no thing or whatever. What do you guys think about a highly interactive show once every week or 2 weeks where it's just very much like responsive to the chat and less focused on reading a document and commenting on it? I don't know if I just want to make sure I'm addressing stuff like that, where we really get in to chat questions and Q&A type stuff. I don't know if that's something that people want or if that should be reserved for like channel member videos or what. But if that's something you're interested in, lots of 1s, couple 2s. What self-respecting law fan would skip the chatterbait section? It would be interesting if you theme it. What is theming? What is theming it? Listener call-ins are disasters. Yeah, and this would only be, again, this would not be every show. This would be like a once a week or once every 2 week show, just to really like, just a me and you sort of talking thing. Say dirty things to chat. Oh, Chat Chan. Oh, Chat Chan. When are we coming together in commonality? All right. Okay. Well, I'll see if we can incorporate something like that. I want to always make sure I'm providing content that people want to engage in and see. And, I don't know what theming it means. So, we'll have to figure something out. Okay, theming, aka having a certain topic or genre, like, I don't know, music or movies. Oh, okay. Well, I mean, yeah, probably something. No, I did a listener call-in show before. I got some criticism for it because a lot of the callers were from my Discord and stuff like that. And the reason that a lot of callers were from my Discord is one, because they had an easy access to get a link from me, which was kind of a benefit of that. But two, because I also knew they wouldn't come on and just be like N-word, 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 N-word. Goebbels was great or whatever. That's the risk of the call-in show, which is just wonderful. Yeah, Mimaru doll, the whole idea of it'd be kind of like this, where the super chat rules would be changed pretty dramatically because it'd be a highly interactive show. That would be the point. So all of it would be very different than a normal show. That's the idea. All right. Well, let's like I said, I've been considering doing that for a little bit here and just making sure we're doing the interactive content as well, and making sure that, everybody gets a chance to participate who wants to. I want to do that as well. So, all right. Let's read the rest of the super chats, then we'll go out. 40K chat stream. Oh man. Oh, speaking of that, just a brief announcement. Again, I will be at Kitchener Comic Con Saturday and Sunday this coming weekend, y'all. And I think I will be having one of the organizers of Kitchener Comic Con on the show either tomorrow or Wednesday or Thursday. We'll figure out which day is best. But to talk about the upcoming show, if you are anywhere near that Kitchener or Toronto area, come visit. It's free. Or you can really splurge and spend $19 on a VIP ticket and get some extra perks as well as helping out the con. Come see me. Come see Vic. Come have a good time. If I can say come just 3 more times, I'll have to move to Chatterbait. Come do it. It'll be great. But they are also getting some heat from apparently Anime North. We're going to dig into that drama a little bit because it is interesting. And we'll talk to them about putting on a con and what their show is like and all of that stuff as well. Get some idea about how they run their business. And it should be a fun show. So make sure to check that out. Follow on Twitter, of course, for various announcements, or you can follow on this channel as well if you want. All right. Let's read these things. Skeet Neat says early and gay. So, well, there you go. Cody Rush says, hey, Nick, I went by Ty's office today. Hopefully he will take my 2 cases I have. By the way, first ever super chat. Thank you for keeping me entertained. Well, good luck on that. And thank you for the first ever super chat. I appreciate it. Stars Girl Forever says, take my money with greed and self-satisfaction. I will do that. Moist John says, depending on the tariff amount, it might be cheaper to pay the mail order. Achilles says, rewatched Ron's deposition. Can't recall a thing. Frederick Little says, again, Nick, I can't wait to meet you and Vic this weekend. I hope Vic wins the case so he can finally move on with his life and live in peace. Hey, me too, buddy. Sakaki Onsai says, Lane Haygood equals illiterate simp plus garbage lawyer. Wow. Wow, that's mean. Jordan Genesis says, how much you want to bet the Vic's case goes to the state Supreme Court, but it's just Judge Chupp in a Supreme shirt? That'd be great. The Iceberg Man says, hey, Nick, greetings from Germany. So Law Twitter thinks that with prejudice means Vic can't appeal. Enlighten them, please. I don't know how to fix Law Twitter. I really don't. They're a broken people. I don't know who hurt them. Probably another lawyer. Marius Van says, buy some Lohan McKinnon peated when in Canada. Lohan McKinnon peated when in Canada. Okay, I'll keep an eye out for it. Goofus Maximus says, when is the verdict from the appellate court due? First, we got to get all the briefs in. Then after that, there will be a time limit that'll come out. And it could be a while. Like I said, probably sometime this summer. Goofus Maximus. Oh, wait, I just read that. Dang it. Angry Baneling says, you are late and gay. What now, Nikki? Get wrecked. Rude. Lil Poo Poos says, Vic whispered, I prefer legal eagle over Rekieta law. Ouch, Vic. It cut me deep. That cut me deep, fam. Ouch. Hyrule 47 says, TLDR, Chup acted like teratoma and conducted the court more like TCPA trial instead of a TCPA hearing. The defendant's brief should be hilarious. Yeah, I agree. Rural sent me a lemon blowing a kiss, which is offensive in many ways. Polio64 says, you ready for Masterson versus Maddox 2? Busby's Folly? Yes. Yes. I gotta talk to Dick about this weird little venue drama he's got going. Sounds great. Skeetneat says, Nick, is it possible for you to do Warhammer 40k book readings on a live stream without getting sued? I want to listen to the story of Perturabo or Trazen. I don't. Only little bits of it. It has to be transformative work. And that's not just reading. It would involve a lot of commentary. If you want an idea of what it would be like, Wolflord Rowe does videos that involve quite a bit of source material from them, where he reads directly from the text, but it's excerpts and it's got a lot of commentary about it to make it transformative. Just reading through an entire book is tough. I did it with Russell Greer's book with Sriracha. We read through the entire book of why he sued Taylor Swift, and that had just a stunning amount of commentary. It took a very long time for a very short book. You know, it was like 10 episodes, and they were 2 to 3 hours each. So it's a lot to make it transformative and sufficiently critical of the work. So I don't know. I don't know if we can do that on the regular show. Maybe we could do that on like a members only show or something. I don't know. I don't know how to do that without getting in a lot of trouble. So I'd be hesitant to do that on YouTube. Esme Illis says, swivel around. Let's see the chair. Oh, what? You want? No, I'll swivel her right off. Rest of the show is being done. No, she snuck back in. Andrew War Snowboard says, what's the best reason for me to go to Matsuri? I mean, Matsuri's just cool. It's a giant spectacle. It's a huge show. The best reason, of course, is it's in Houston. So when you're done with the great show itself, you can just go eat at Ninfa's downtown or something. That's why. Siren Jag says, I am braving the 10-hour drive to Kitchener on Friday. If you want to go but need a ride and you live on the path through Columbus, Toledo, and Flint, DM me on Twitter. There you go. If you need a ride to Kitchener and you live somewhere on that path, you got a driving mate right there. Colfie 2A wannabe Haunan Mohammed says, a kiss-blowing lemon is tasty with plenty of sugar on it, like a Monica jelly bean. You, sir, are not good. Not good. I cannot endorse that. Next, Bibbity Gibbet says, "Hey Nick, last show someone was looking for a cheap whiskey that was good. I would suggest Deanston Virgin Oak. Sells for $50 Canadian or $37 US and is drinkable, but that is the lowest I would go. If you want cheaper, go with a nice dark rum." There you go, whoever was asking for that. And Universal Remote says, "Just a reminder to Ron that he hasn't changed and that he is still a dumpster fire of a person." Abso-fruitly. That guy sucks. All right. All right, guys. That's the show for today. Let's go ahead and get this outro playing at a reasonable volume. And if you want to come join me on Twitch, you can do so. What am I going to play tonight? I don't know. I did the Commando Challenge on Risk of Rain 2 yesterday. I was able to actually do 20, complete stage 20 without getting any lunar items. I did. I completed stage 20. I was flipping invincible, got no lunar items, through it, got to stage 21. And then I got the lunar beads because I was going to go do the anal bead challenge. And once I got the beads, I got a shaped glass and I left the bazaar to go to the next stage and it froze and shut down. So I still got the achievement, but I wasn't able to continue on with the run and go do the anal bead challenge, which is what I really wanted to do to defeat that monster, and I didn't get to because my character was too tough. So, there you go. Dark Souls 2, let's go. I was thinking I'd do Sekiro before Dark Souls 2. So, we'll see. But I'm not gonna play Risk of Rain 2 tonight. I was just bringing that up because that was an endeavor. We're gonna play some not tonight either, but we're gonna play some Warhammer 40k Deathwing. Space Hulk Deathwing Enhanced Edition is coming sometime soon to Twitch as well, and I think it has Twitch integration in it, so you guys can like spawn monsters and stuff as well. So that should be fun. But yeah, stay tuned for that. I've got a couple dudes who play, and so we'll be doing some co-op. That thing. But I did install it. It runs like a dream. Sometime. Malik Foxen says, "Did you ever get a hold of the body language expert to go over the depositions for a stream? Imagine it's not as relevant now, huh? Would have liked to see." I did not get a hold of them to go over them. I mean, it's not as relevant, but it's still very interesting. I could still reach out. It could become very relevant. If this thing goes back to trial, then those people go on witness stands, and that matters a ton. So, I don't know. I'm really trying to balance the Vic content prior to the appeal. I'm really trying to do that. I want to make sure and give you guys the appropriate amount of updates and stuff like that on Vic stuff, but I mean, at this point, some of you feel very burned out on it. Believe me, you're not alone in that. I've been talking about this same stuff for a year as well. So I know. And I want to make sure we're bringing in fresh content as well. So I'm working on that balancing act. But. All right, guys, come join me on Twitter. I've talked through the entire song. Oh, my God. See y'all later.